My name is Chua Li Earn, and this is my presentation for the Equity and Trust 2 assignment. This discussion will be based on the English law position. Resulting trust is a form of implied trust which, in contrast to express trust, do not come into existence by the design of parties who knowingly and intentionally create it. Instead, resulting trusts arise on the operation of law, determined by fact patterns where equity stipulates that a trust should arise in response to particular circumstances. Resulting trusts are often difficult to navigate, as they arise only when declared by court, and includes varied circumstances where it is applicable. This complexity has led to ongoing academic discourse on the theoretical foundations of resulting trusts. In this video, we will critically examine the roles of intention, legal presumptions, and unjust enrichment in relation to resulting trusts. Before we dive into the theoretical discussions, it is important to understand the current law. There are two main contexts where resulting trusts arise. This has long been identified by the courts of England and Wales. The earliest case which established the two main types of resulting trusts is the case of Lloyd and Spilett in 1740. However, it was not until the landmark decision of In re Vandervelde's Trust, Justice Megri highlighted these contexts where the resulting trusts arise, and classified them into automatic resulting trusts and presumed resulting trusts. From how the resulting trusts are classified, the descriptors employed by Justice Megri describes his views on the intention aspect and how those trusts arise conceptually. In Justice Megri's conception, automatic resulting trusts arise as an automatic consequence where there is an express trust, but either the whole or part of the beneficial interest fails to transfer to the beneficiary. This class of cases are the failing trust cases. It does not depend on any intention or presumption of intention of the donor. This position is consistent with Lord Reed's position in Vandervelde and Inland Revenue Commission, where he applied the equitable maxim that equity abhors a vacuum. As the interest cannot remain in the air, the consequence in law must be that it remains in the settlor. Hence, the automatically resulting trusts arise as a legal consequence independent of intention, and the trustee holds the interest in resulting trust for the donor. On the other hand, presumed resulting trusts arise in a transfer not made under any express declaration of trust to the transferee. There are two different circumstances under this context. One, the transferor had made a gift of property to another by voluntary transfer of property. This is the voluntary transfer resulting trust. Or the second one, by contribution of the whole or part of the purchase price of the property. This is the purchase price resulting trust. A rebuttable presumption arises that the recipient is holding the property on resulting trust for the transferor when the circumstances are set out. This presumption is the evidential aid to infer intention. Where there is no evidence to rebut the presumption shall manifest to establish that the recipient is holding the entire interest of the property, including the beneficial, on trust for the transferor. This class of cases are the apparent gift cases. However, Lord Brown Wilkinson, in the case of West Deutsche Landesbank and Islington London Borough Council, elected to not adopt Justice Megri's classification of resulting trusts. Instead, he made his own classification based on the same two contexts of apparent gifts and failing trusts, and termed it as Type A and Type B resulting trusts respectively. The reason for Lord Brown Wilkinson's departure is due to his disagreement with Justice Megri's use of terminology in classification. Lord Brown Wilkinson's opinion was that trusts falling under the failing trust context do not operate automatically. His view is that both types of resulting trusts are traditionally regarded as examples of trusts giving effect to the common intention of the parties. Hence, it can be seen that intention plays a part in the nature of resulting trust as a grounds for imposing the trust. However, there is no satisfactory position of what is the type of intention and the doctrinal foundation of the intention. The courts labeled the intention in a mostly broad and general manner. Therefore, we have to look to academic discussions of what is the type of intention required to establish a resulting trust. There are two main competing theories. The first is the Swadling-Brown-Wilkinson school, which suggests that resulting trusts are governed by a positive intention. The resulting trusts arise from the presumed intention of the parties to create a trust, while the Burks-Chambers school of thought suggests that resulting trusts arise from a negative intention, that the interest in the property results back to the transferor due to a lack of intention of the transferor to benefit the recipient. Both schools of thought have been endorsed and acknowledged by the courts. However, they are also not free from their own criticisms. First, we look at the traditionalist position taken by Swadling and Lord Brown-Wilkinson. Although their views are lumped under the same positive intention theory, their arguments vary. Lord Brown-Wilkinson believes that resulting trusts give effect to the common intention of the parties, while Professor Swadling believes that the resulting trust is simply an express trust whose distinguishing feature is the fact that the declaration of trust is proven by presumption rather than by direct evidence. The biggest issue with Lord Brown-Wilkinson's views on resulting trusts arising based on common intention of the parties is that it cannot be reconciled with the decision reached in previous cases, specifically in the cases of automatic resulting trusts. For example, Vanderbilt and Inland Revenue Commissioner. In that case, no inquiry was made on the transferor, Mr. Vanderbilt's intention at the time of the transfer. In fact, there was even direct proof and admission by Mr. Vanderbilt to part with the shares and all its interests. However, the court still applied the automatic resulting trust on the basis that he failed to divest himself of all beneficial interest in the property, and the beneficial interest still resulted back to him, contrary to his intentions. Hence, Lord Brown-Wilkinson's arguments that automatic resulting trust arising from the common intention of the parties does not stand when applied in case law. On the other hand, under Swadling's traditionalist positive approach, he explicitly restricted his theory to only the presumed resulting trust class of cases and states that his theory cannot explain automatic resulting trust. Hence, his theory cannot provide a unifying principle for the two classifications of resulting trusts. Moreover, it is argued that under Swadling's views, where the declaration of trust is proven by presumption, he has confused the substantive legal rules involved in the voluntary transfer of the property with the legal act of self-declaration which creates an express trust. He has mistaken such an act as evidence of intention. Moving on, now we look at the Burks-Chambers theory of negative intention, where resulting trust arises when at the time the property was transferred, the recipient was not intended by the transferor to take the beneficial interest in the property. Hence, the resulting trust arise to return the property to the original owner. This view is also supported by the case law, specifically through the affirmation of such theory by Lord Millett in the cases of Air Jamaica and Charlton, and Twinsectra and Yardley. One clear strength of this theory as compared to the traditionalist Swadling theory is that the negative intention provides a unifying principle for both classes of cases under resulting trust. This theory is also the theory which provides a justifiable explanation for the peculiar quist-close type trust where money is lent for a specific purpose, and when the specific purpose cannot be carried out, that money results back to the lender. The negative intention theory was affirmed by Lord Millett in the case of Twinsectra that because the lender never intended to benefit the borrower, the resulting trust arose in the lender's favor. However, it should also be noted that Dr. Mee had opined that the negative intention formulation is often used interchangeably in the same source with a positive formulation, which shows that clearly that they are both being used to state the orthodox position. This raises the question on whether the previously discussed school of thoughts actually have any relevance in legal reality. Now, we move on to the role of presumptions in resulting trusts. The issue of presumptions only arise in the context of presumed resulting trusts when there is either voluntary transfer of property or a purchase price contribution scenario. Because proving intention to hold property on trust is difficult, presumptions are used in aiding the court to decide whether there was an intention for the transferee to hold the property on resulting trust for the transferor. This is commonly known as the presumption of resulting trust. Alternatively, within the same presumed resulting trust context, due to the prevalence of voluntary conveyances of property or contribution to purchase price between persons where it was commonly understood that gifts of property based on love and affection would be made, the presumption of advancement may arise to displace the presumption of resulting trust. Part of the issues that arise with the role of presumptions is how often academicians mistake and conflate the presumption of resulting trust with the resulting trust itself. However, these are two different things. The presumption of resulting trust is the evidential rule which arises upon proof or admission of a primary fact, and it provides the benefit of secondary fact without proof being required. This shifts the evidential burden onto the other party to adduce evidence to rebut the presumed intention that the transfer was not intended to be a trust but a gift. On the other hand, the resulting trust which arises from the manifestation of this presumption is the legal response triggered by secondary facts. Along the same lines and same rationale, the presumption of advancement operates in the same way. It can be noted, however, presumed resulting trust itself and the usage of these two presumptions have met cold reactions from the English courts. The reason is that presumed resulting trust and the basis of how the presumption of resulting trust or the presumption of advancement arises has remained static with little change in the law, specifically the type of primary facts which will raise a presumption. Hence, it has been criticized that presumed resulting trust and its equitable presumptions are also outdated, not aligning with current social contexts and standards. Citing Lord Diblock's stark observation in Petit and Petit, he states that the nature of equitable presumptions of intention are no more than a consensus of judicial opinion disclosed by reported cases as to the most likely inference of fact to be drawn in the absence of any evidence to the contrary. Following this dictum, as observed by Dr. Mee, resulting trusts are historically rooted in resulting uses, whose primary point was to facilitate a subsequent declaration by the grantor of his intentions in relation to the property. Therefore, the presumption created by the courts was that the transferee should hold the land on trust for the transferor. It can be seen that the primary facts raising a presumption of resulting trust is the same even for case law as early as the 18th century, such as Dyer and Dyer, where the presumption of resulting trust arises with contribution to the purchase price, and also the early 1900s, such as in Re Vinogradov, where the voluntary transfer of property raises the presumption of resulting trust. Therefore, it can be understood why the courts have gradually shifted away from presumptions of resulting trust and consequently presumed resulting trust, specifically after the landmark decision of Stack and Dowden and Jones and Kernet, which establishes for the common intention constructive trust to be the default in domestic consumer contexts, but not merely limited to it. In fact, the categories of context applying common intention constructive trust have expanded. The courts in Ghani and Han even confirmed that in modern times, the presumption of resulting trust should only be used as a last resort. Archaic applications of presumption of resulting trust do not conform with current social standards because it does not align with the practical reality faced where parties normally do not expect that the difference in contribution price will lead to different percentages of interest in the property, and it overlooks issues such as gender pay gap and household contributions. These considerations prompted the shift of the courts from presumption of resulting trust to the common intention constructive trust, which reflects social context better. The same issue arises for the presumption of advancement, where the fixed category of special relationships which give rise to the presumption that the transferor intended the property to be transferred as a gift is rooted in gender discrimination. Finally, we move to the role of unjust enrichment in resulting trust. It is observed that it is a reasonable inference where resulting trust and the proprietary restitution it provides can be regarded as a remedy for unjust enrichment. However, the issue with the intersection of unjust enrichments with equity lies in the Burks-Chambers theory. In addition to this negative intention, Burks and Chambers expanded their arguments to state that resulting trusts operate to reverse unjust enrichment because the provider of the property did not intend to benefit the recipient. Hence, the creation of resulting trust is a response to unjust enrichment. However, this position has been largely criticized. The main reasons that this position is criticized is because a conception of negative intention does not necessarily entail that all resulting trusts respond to unjust enrichment, or the wider proposition that all cases of unjust enrichment should trigger a resulting trust. This particular theory is incorrect because it distorts trust principles. Burke's-Chambers' argument neglects that a trust can only arise in defined trust properties. The undue expansion of categories of resulting trust, which will inevitably happen if this argument is accepted, will result in a proliferation of proprietary remedies, which will turn most unsecured creditors into secured creditors, destroying the established laws of insolvency and priority in case of bankruptcy. Moreover, in the law of unjust enrichment, the creation of resulting trust is not a recognized unjust factor, which warrants a claim in unjust enrichment. Hence, it is indicative that this is not a case where the defendant has been unjustly enriched. In conclusion, intention, presumption, and unjust enrichment each contribute to the understanding of resulting trust, but none offer a complete or untested foundation. Intention, whether positive or negative, remains conceptually unsettled, while presumptions are evidential tools often confused with the trust itself, where there is also a shift in legal trends in applying it. Although unjust enrichment offers a possible rationale, it risks distorting trust principle and undermining insolvency rules. As such, resulting trusts continue to straddle competing theories without a single unified doctrinal basis. This is the end of my presentation. Thank you.